All right. So it is 11:02. Good morning, everybody. My name is Austin Northland, and I am the marketing director at Bankers Insurance. And we are here with Jamie Hasty, Vice President of SESCO Management Consultants. And she's going to be our presenter today. We are going to be discussing how to conduct internal investigations. And just a few housekeeping notes before we get going. This webinar is going to be recorded, and I believe everyone is muted. If you have any questions throughout the webinar, feel free to pop them into the chat. We will be addressing those at the end. We will also have a Q&A at the end, so feel free to hold your questions until that point. And without further ado, we will go ahead and get started. I will pass it over to Jamie.
Thanks, Austin. Good morning, everybody. Hope everyone is doing well. Give me 1 second. Let me share my screen here. Make sure I pull up the right screen. You all don't want to see half of what I've got going on my tabs, right? So I really actually enjoy this topic because we get a lot of questions at SESCO, whether you're a banker's client or some of the other clients that we work with throughout the entire country on, Jamie, I've got this situation. I'm not quite sure how to run this investigation. And certainly that's something that SESCO comes in and does a lot for our clients, just for that impartial, objective look. But conducting an internal investigation, whether it's tied back to harassment, discrimination, whistleblower sort of information, in theory, the structure needs to be the same, right? So we want to kind of cover this topic. As Austin mentioned, the session is being recorded. Certainly you'll receive a copy of that along with a copy of my PowerPoint as well. If you have questions, please feel free to use that chat feature. I'll do my best to get through all of those before we wrap our time together. But I want to start with the importance of investigations. Why is it important? When we have individuals that come to us, whether it's to a supervisor or to human resources, or if you're a smaller organization, perhaps that is an office manager, somebody that is kind of that point person, we have a duty to respond. And every employment handbook should be a complaint procedure as well, whether that be tied back to a performance write-up or something that is going on that would violate a company policy or procedure. We have responsibility under a variety of state and federal regulations to investigate. And certainly our investigations and our policy and our procedure and our defense of those is going to be our front line and making sure that we both prevent wrongdoing from occurring and promptly correct it if some sort of harassment or discrimination or bad behavior in the organization has occurred. Now, again, this doesn't always have to be tied into harassment or discrimination. It could be about theft. It could be about communication issues or mistreatment or bullying. I mean, you can really apply these concepts to a variety of things. But so when we talk about federal laws that dictate why we do investigations, most of them are going to fall underneath the Department of Labor, the EEOC, the Equal Employment Opportunity Commission, because in many scenarios, a lot of times the investigations are tied back to an allegation of harassment, bullying, discrimination. My manager's not treating me properly, this coworker is being ugly to me, what have you. So the EEOC and Department of Labor, whether it's Title VII, Americans with Disabilities Act, Family Medical Leave, Pregnancy Discrimination Act, in Virginia, Maryland, each state has their own requirements as well in terms of job protection laws. They're all going to require us to investigate. We also have to have adequate policy and complaint procedures put in place in our policy and procedure to make sure that we are upholding our responsibility both to the law, but also to the employee. So we have to show that we exercised a duty of care, that we are taking allegations of wrongdoing seriously, that we are looking into them factually, objectively, and that we are taking appropriate corrective action if something has in fact violated policy, procedure, or regulation. And so EEOC, Department of Labor, says when employers receive complaints, kind of just sweep them under the rug, where they say, oh, that's just so-and-so, or we're adults, y'all need to work it out. We're not exercising our duty of reasonable care. And those are situations where the Department of Labor will really hone in on, and look for, what our investigation yielded. Did we conduct one? How quickly did we conduct one? All of these things. And so again, it's about being able to put the organization in a defensible position with the Department of Labor. So good investigations are ultimately going to save you money. We are in a highly litigious society. There are various ways in which individuals can file complaints against the employer, whether that be through State Department of Labor, civil litigation, or federal Department of Labor. And so we've seen lawsuits, especially now here in Virginia, because they can circumvent having to go through the DOL. They can move straight to civil litigation, are up roughly about 400% in the last 20 years. Okay. More than 40% of those complaints filed against employers have anywhere between 15 to 100 employees. And so, depending on what you're looking at in terms of the definition of an employer size, 15 employees, 20 employees, 50 employees is not a large organization in the grand scheme of things. So roughly about 24% of litigation as well as complaints are filed with employers that have over 500 employees. So when we have complaints, if they go into civil litigation or even through the Department of Labor, there's a lot of money tied into this, not just with legal fees, with paying consulting fees to do the investigation, to defend the charges, all of these things. But if we are found to have violated policy and procedure or law, then we have situations where we get into liquidated damages, we get into compensatory damages, punitive damages, back wages, attorney's fees, interest, all of these things. And there are chances where some of these penalties associated with the allegation of wrongdoing can exceed $1 million. If I look at what the average compensatory award in federal court is, it's roughly about $500,000. Okay, so we want to make sure that we have good procedures in place to address situations when they arise. The other piece to think about is when we have internal complaints. That's a stressful situation for a lot of people. And so we want to make sure that we have procedures and things, readily available to avoid as much as we possibly can staff distraction. It's stressful. It's, a very short time frame from when we have to start and finish these investigations and take appropriate corrective action in the eyes of the DOL. So we want to try to limit that distraction, that stress, and that effort as much as we can by having good procedures. You all are well aware that when there are issues within the organization, that can significantly impact employee morale. The rumor mill gets out, the gossip mill, people are speculating. And so that can take a significant impact on your culture and your morale and your motivation. We're also in a society of social media. So TikTok, Twitter, Instagram, all of these things can go viral very quickly. I had a scenario a few years ago where one of our healthcare organizations in the state of Virginia had made a separation of employment tied to performance, However, there was not really great documentation in the file from the manager regarding attendance and performance and these sorts of things. So this person felt like the separation of employment was not legitimate, felt like it was tied back to discrimination based on disability and race. And before you know it, the HR director is leaving in the evening, and the 5 o'clock news is stationed out in their parking lot doing a news story, and caught her off guard and wanted to interview her right then and there. So, there's a lot of potential for damage to reputation, organizational reputation, as well as individual reputation of management. And we certainly don't want to be perpetuating those bad practices. So when there becomes trends, when there are successful lawsuits on certain topics, that sets case precedent. That sets Department of Labor interpretation and precedent of how they're applying these scenarios. And so it tends to yield more trending in those topics. So we have a few goals in our procedures. First, again, back to reasonable care. Your investigation needs to be prompt. That's why it's nice to have policy and procedure already in place, knowing who is on the receiving end of the reports, what are going to be our next steps, so that when we get internal issues, that we are able to promptly jump in and start our investigation process, because we want to avoid future misconduct. Whether it is a charge of hostile work environment or discrimination, especially if it's a current employee that's still working for us, we need to make sure that we're stopping any sort of alleged behavior and preventing it from happening again. Because if we do not, there's a chance for retaliation. There's a chance that a second charge, a second allegation of retaliation will soon there follow, okay? We also have to keep things as confidential as we possibly can. Human resources is tasked with all sorts of confidentiality, as well as leadership has a duty to keep things confidential. So we need to make sure that the right players are at the table, and that we're not divulging anything that would breach confidentiality, that we are decreasing the fear and the likelihood of retaliation. And then lastly, it has to be a thorough and impartial investigation. When we're doing these investigations, a lot of times what we'll do is look at, okay, what is the allegation at hand? Is the person, the manager, able to participate in the investigation, or are they not? Are they too close to the situation? Is the allegation against them? Is it, are they skilled in interviewing techniques and skilled in the regulation? So we have to make sure that the employees that are making the internal complaints, feel comfortable that it is an objective and impartial investigation, that the goal is to find the truth to the best of our ability. And that tends to help reduce and prevent lawsuits that we didn't conduct a fair and complete investigation. So, important considerations. What triggers an obligation to investigate any sort of internal complaint? So if we have knowledge, we've heard a rumor mill, somebody has made a formal complaint, that's going to trigger investigation. Now, it doesn't have to be this full-blown dog and pony show either. A lot of times, internal investigations occur quietly, competently. We document, we get statements, we take appropriate corrective action, and we move forward. Depending on the topic, it might be a little bit more robust. Last fall, I had a situation where there was an allegation of employees selling or exchanging, excuse me. Well, I guess they were exchanging marijuana products on company property, not during company time, but company property here in the Commonwealth. Well, we all know that Virginia has changed their regulation on marijuana laws. However, if you pull the regulation, any sort of exchange of product, whether it be a gift or in exchange for money, is still technically a class 1 felony. So once leadership got word of this rumor, we had to investigate. We had to bring in people. We had to determine who were the players, what occurred. We had to pull security cam footage. So something like that could trigger an investigation. And time is of the essence. So we have to make sure that once we have knowledge, that within 3 to 5 days, we have initiated the process, we have done what we needed to do, and we're trying to wrap up by day 5 within reason. Certainly, schedules can impact that, especially in the summertime with vacations and that sort of thing. So we also have to look at, is the investigation considered an adverse action? What is an adverse action? An adverse action is going to be a situation where I am changing the terms and conditions of employment. I am treating somebody differently simply because they came forward with a complaint. So, I've seen situations where an employer will receive information or receive a complaint, and the way that they structure the investigation is very aggressive, very intimidating. And then the employee who made the complaint feels like, oh, I'm being treated differently because I came forward. So we certainly want to avoid adverse action. I get a lot of questions from clients about, what do I do when somebody comes forward and says, oh, so-and-so is bullying me, or so-and-so has said inappropriate things to me in the department. And what do I do with them? They don't want to be here. Do I send them home with pay? Do I temporarily suspend the person that they're accusing of the wrongdoing with or without pay? And there are some tricky rules that come into play when we're talking about exempt versus non-exempt employees. But certainly, if you have somebody that is coming forward that has made it clear they're uncomfortable with the situation, you can give them options. You can say, well, you're welcome to stay if you feel comfortable with that. If you'd like to go home, we'll go ahead, take a day or 2 off. I try to avoid requiring them to use vacation time because, again, it's an internal complaint in accordance with our complaint procedure. They could then say, oh, well, I was penalized by being forced to use my vacation time or my sick time because I came forward with a complaint. So that would be a potential allegation of adverse action. Does that make sense? So the complainant, we have to make sure that we are providing protection to, but also it is perfectly within your right as an organization to say, look, we've received a complaint against you as the alleged harasser, as the alleged individual of wrongdoing. We're going to go ahead and put you out without pay while we do our investigation. Now, if they're salaried exempt, remember, wage and hour regulation requires them to be guaranteed that full salary for that week, regardless of the number of hours that they work. If they're non-exempt hourly or non-exempt salary, they're only paid for the time that they actually work. Could you give them the option as the alleged harasser of using paid time to make them whole? Absolutely. So another thing that often comes up in these complaints is an employee may come to you and say, I'm going to tell you something, but I really don't want to get anybody else in trouble. I just want you to know. Okay. And I get it. Nobody wants to be considered the tattletale, or, they may be not necessarily fully comfortable with, the whole investigation or bringing attention to the investigation. But if we have knowledge, we must act. We cannot take into consideration an employee asking us not to investigate. Okay, so that's something that you need to be mindful of, is we have a duty to respond. If it violates company policy or procedure or state or federal regulation, we must investigate. And then we need to look at who's going to conduct the investigation. When do we get consultants or attorneys involved versus internal? Truth be told, that's going to be based on the facts and circumstances of the situation. You know, a lot of times we will get calls or questions about a situation that is unfolding or that's been brought to the attention. And that's why I start talking about, well, who could sit at the table, who has the skill set, who can be impartial. And that's why a lot of organizations will actually outsource those internal investigations to make sure that it is complete, transparent, and impartial. So we investigate again when any information is going to come to light, whether it's any source, customer, vendor, employee, that would violate law or company policy. Some organizations have complaint hotlines, tip lines, complaint boxes. But even if it's a rumor mill, a gossip, depending on the topic, that's going to trigger an investigation. So we have to thoroughly investigate that and document from start to finish every single step along the way. Okay. So when we get complaints, what we want to do is create an initial separate file for each investigation. Also remember, anything in that file is going to be considered potential discoverable. Okay, so if it is a subpoena, you got to give her the whole file: text, emails, social media posts, all your notes, applications for employment, their employment file, everything is discoverable. So, you know, somebody can make an allegation of, you know, discrimination through the screening and hiring process. That's why managers need to be trained appropriately on things that they can and cannot ask. And that's why we also tell individuals, you never write on the application or on the resume, because I've dealt with cases in the past where the application was subpoenaed. And there was something written on the application that was interpreted as discriminatory, even though it wasn't intended to be discriminatory. So all of these things are discoverable. So this is also a friendly reminder that our leaders within the organization need to be reminded that sarcastic comments, emails, notes, videos, you know, all employees, regardless, technically, all of that can be in front of a jury. So we always want to think about the records that we're creating and retaining that could ultimately make or break our case. Remember that, particularly here in Virginia, but even in Maryland and surrounding states, that's a single party consent state. So in terms of recordings, as long as it's not in a bathroom or dressing room or bedroom, somebody could be recording the conversation without other individuals' knowledge. Okay. So those things are also considered discoverable. If you have in-house counsel or you have external counsel, when you are talking about particular employee situations or employment actions, you can certainly copy your attorneys where it's appropriate, because that creates that attorney-client privilege protection as well. Okay. So steps that we want to take in an internal investigation. First and foremost, we have to ensure confidentiality. And that's to the best of our ability. When you dig in, we're going to have to say, look, we've received a complaint against you about X, Y, and Z. Depending on what the topic is, depending on what we're questioning them about, they might be able to figure out who made the allegation. Okay. But certainly we're not going to say, oh, well, Susie accused you of X, Y, and Z, or Mark said you said this. That's not what we do in our investigation. There are ways of structuring the line of questioning to avoid blatantly using the alleged victim's name in the line of questioning. And also, when we are initiating the investigation, every individual involved in this investigation should be explained our stance on confidentiality. Breaching confidentiality could be considered interfering with the investigation. Sharing information with people that are not involved in the investigation would be a breach of confidentiality. You know, we're only sharing information with those on a need-to-know basis, and we ask that you do the same. Here are the people that we can speak with regarding this situation. Okay. Step number 2 would be, as I mentioned earlier, providing interim protection. So, especially if we're dealing with harassment or discrimination, hostile work environment, quid pro quo stuff. It might be necessary that we need to separate the victim from the accused. Okay, we certainly don't want to engage in any sort of retaliation or continued harassment, whether that be from the one that's accused or from other people within that department, especially if confidentiality was breached. So you could do a schedule change, you could do a transfer, you could do a leave of absence. However, we should not be involuntarily or requiring them to be transferred or burdened. That's how you're going to get a claim of retaliation or a claim of adverse impact. Step number 3 is that we need to select our investigator. Again, it is a skill set. It is somebody that can look at the investigation objectively. If we're talking about Title VII harassment and discrimination, the language there is going to be a reasonable person standard. Okay. So we need somebody that can look at things factually, that can dig through fact versus fiction, that is skilled at kind of peeling back the layers of the onion, and asking probing questions, and that certainly have no stake in the outcome. Again, that's why most organizations will outsource these internal investigations, because the consultant, the attorney, doesn't have a stake in the outcome at the end of the day, right? Their job is just to get to the bottom of it as best they can. So prior knowledge and working knowledge of employment laws is really helpful. Also have to have very good, strong interpersonal skills, attention to detail, being able to pick up on nuances, to read through body language, to look at inherent plausibility, all of these things. And that can maintain confidentiality. Now, certainly that might be your senior leadership team, your human resources individual, your chief operations officer, your operations director. You know, it doesn't always have to be external, certainly helps. But you might have individuals within the organization that kind of check all these boxes. And if so, that's wonderful. But we also need somebody that can act as a credible witness, that is also respected within the organization, and that could not be challenged on their credibility or impartiality. So then step 4 is, once we've decided who's going to investigate this, we need to create a plan for the investigation. We want to make sure that we have a list of the alleged complainant, the alleged, harasser or person of wrongdoing, any witnesses, anybody else that we need to kind of speak with. And then you kind of have to plan out where do we need to start? Who should we start with first? Typically that's with the alleged victim. And then based on what their statement is, they may be giving names or reference certain things, and that kind of drives the initial plan of sources of information, evidence that they may have, and that helps us also tweak the interview questions so that we can target down and hone in on that crucial information, those details that we're going to be, requesting copies of. Also, speaking of copies, let me go back here. Just because it may be a text message on a personal cell phone or a, social media post or what have you, all of that is considered discoverable and can be subpoenaed as part of the investigation. So I always try to remind my staff members of that as well. And then once we have our list of people that we need to speak with and where we might be looking for evidence, then we develop our interview questions. Your questions need to be fairly consistent, but your interview questions for the victim, the accused, and third party witnesses, they're going to differ a little bit, not significantly, but a little bit. So typically I want the basic fact finders, the who, the what, the when, the where, the why, the how. What happened? Who saw it? Who heard it? When did it occur? Has it stopped? How did you address it? How did it make you feel? How did it impact your ability to do your job? What was your reaction? Did you establish that the behavior was unwelcomed? Trying to really get specifics. I've seen situations where managers have said, "Oh, we'll just write it up and I'll look at it and we'll go from there." Not my favorite approach, truth be told. Again, because a lot of times there are employees who will leave out very valuable information, or their statement that they've written themselves may be unclear, and then we have to flesh it out. So typically what I recommend is that when you're meeting with the alleged victim or the person making the complaint, is that your skilled interviewer is going to ask the questions, type up, if they feel comfortable doing that, a summary of what they're saying, and then allow them the opportunity to review that, print it out, let them look at it, let them make edits. We're human in nature, so there are going to be misspells or something was unclear and we need to flesh it out. But we tend to yield better results and have more information when HR or the manager is asking the questions and putting together the statement. But not always. There are a lot of employees that will give you pages upon pages of statement, and they're very detail oriented. So again, I think this goes back to knowing your people. It can be very frustrating to employees if you ask them to put something in writing, surrounding their complaint, and then we have to go back 3 or 4 different times and say, well, what about this? Or you left this out, or this is missing. So it just kind of helps things move quicker, and we know that initial statement is going to be as comprehensive as it possibly can be. So here are some sample victim or complainant questions. Who else knows what happened? Are you aware that anyone else has had the same or similar experience that you've had? Perhaps they have knowledge that, well, so-and-so dealt with this 6 months ago. Well, that means I'm going to need to either go back to the file and see, was there a complaint from that person? Was that investigated, or did we have any knowledge of it? If we didn't have any knowledge of it, then I need to speak with that person and try to figure out what happened for them. So the investigation can quickly expand outside of that initial complaint, because now we have subsequent kind of areas that we need to address as well. Are there any notes, documents, physical evidence? How has it impacted your job performance? And most importantly, and you always have to put a caveat on this last one, how would you, in a perfect world, like to see this be resolved? Now, that does not mean that the victim or the alleged complainant gets to dictate how we're going to address this, but it helps us gain a better understanding of where are they at in this process. Are they expecting somebody to lose their job? Are they just expecting the behavior to stop? Are they asking for permanent separation from these people? So I always like to ask that question because it helps me figure out where their expectations are. But again, I always preface it with, it doesn't necessarily lock us into this is exactly what we're going to do for you. As a reminder, the law says we simply have to stop the behavior and prevent it from happening again in the future, or we have to just take appropriate corrective action. Okay. So with our witnesses, and really, I always advise everybody of this, but you know, being identified as a witness can be a little intimidating, I think, for some. And so we want to always reiterate the importance of telling the truth. They're not in trouble. We're just trying to get to the facts versus opinions. It's necessary for us to speak with them. We need their assistance. And then we always are going to ask appropriate open-ended questions. What did you see? What did you hear? What were you told by the accused or the complainant? Again, is this hearsay or is this something that you actually witnessed? Are you aware of any evidence? Do you know of any other people outside of you that would have knowledge of this information? And then also you want to make sure that your witnesses are informed that because of confidentiality, and because of what policy and procedure state, they're not necessarily entitled to be notified of the outcome of the investigation. Okay. Really no one is, even the alleged victim. I'm not going to say, oh, well, I fired Johnny, or, oh, I fired Susie. Certainly if somebody has lost their job and we've separated employment, and they don't show up again, that kind of speaks for themselves. But in terms of employment actions taken against other employees, all of that is required to be confidential. So we reiterate the importance of confidentiality, and then we do a lot of listening. Again, probing, asking clarifying questions, asking what things mean, documenting that witness statement, just like we would any other complainant and victim statement there as well. So then once we get kind of our questions plotted out, we actually conduct the interviews. I always like to start off by explaining why we're meeting. We've received an internal complaint against this topic. You've been identified as having knowledge of said complaint, or you've been identified as being involved in the complaint. This is, we have an urgency to look into allegations, and we have a strict policy on confidentiality. My job is to listen, to ask you questions, to take notes. And then I'm going to be typing out your statement, and I will give you an opportunity to review that statement. It is within your purview to make any necessary edits that you feel to make that statement true and accurate. And once we've gotten your statement true and accurate, then I'm going to ask you to sign and date it. Okay. So I kind of just lay out the whole process for them from start to finish so that they feel comfortable. You don't want to get into too much chit chatter up front, but you also don't want to be stone cold. Again, this goes back to interpersonal skills. You need, people get nervous when they're sitting with human resources or an outside consultant who they have no idea who it is. And you want to make sure that you're kind of being cordial, but being impartial, never offering any sort of opinion. I've seen way too many situations go sideways where the investigator's like, oh, wow, yeah, that is really offensive, or I could see how that would upset you. We can't do that because then that means we're not being impartial. We certainly don't want to discredit ourselves as the investigator or the person leading the conversation by providing any sort of opinion or saying something that would lead witnesses or other individuals involved to believe that we are anything but impartial. So a few reminders here. You got to plan your interrogation, for lack of a better phrase. Prep pays. If this is your first one or your 100th one, you still have to prepare. If this is something where you're not necessarily super comfortable in doing the questioning, role play with another manager, practice in the mirror. You want to make sure that you have all of your documents ready to go, all of your facts from the initial internal complaint, so that you can ask appropriate questions and keep all of the names and details straight. But we also have to listen. Try not to interrupt, try to be thoughtful, try to make good eye contact there. That's really important as well, because our goal is ultimately to find the truth. And sometimes that's very difficult. Sometimes there are no witnesses. Sometimes there is no quote unquote evidence to back it up. It becomes a they said versus they said, or it's purely a matter of perception, which based on law, perception matters, especially if we're dealing with harassment or discrimination. What's appropriate and reasonable to me is not appropriate and reasonable to you, and vice versa. So we want to take our time. We don't want to drag things out, but you almost have to let the interview unfold naturally too. We want to make sure that we're not rushing. We're giving people time to think about the question and answer appropriately. We're giving ourselves time to ask clarifying questions and probing questions, because we don't know what happened yet. And certainly if something starts to become corroborated, we don't want to necessarily let others on to that. Again, until you have spoken with every single person, we've dug through facts and come up with logically what may have occurred. Okay. So with the interviews, certainly we need to look at credibility of the individuals that we're speaking with. So we're looking at inherent plausibility first and foremost. Is there a situation where this could have occurred? Is it inherently plausible that it happened? Yes or no? Is this something so outrageous, so outlandish, that it makes us a little suspect? Perhaps. Is it based on the information that the alleged victim is bringing forward, that the person that they're accusing was even there that day? You have to look at, does this make sense? And sometimes they don't. Sometimes they are wild. The conversation is all over the place, or dynamics between a manager and an employee or another coworker are a little fuzzy and a little gray. So we've got to kind of figure out what really is going on. I had a situation that just came up yesterday where an employee was counseled on their uniforms by another employee. Then there was this back and forth between the two employees about how, the one employee felt like the one that didn't have their uniform and other stuff was purposely trying to upset the manager, and then the other employee said, yeah, well, I want to make them mad, I don't care, blah blah blah. And then when the manager reached out to him, then all of a sudden this conversation went from about, hey, remember, you can't wear Crocs to work, to suddenly now there's an allegation of sexual harassment against another employee, and I'm going to do this and I'm going to do that. And so things can quickly evolve. Even if it didn't start as an internal complaint, it could have been a coaching situation. It could be a separation of employment. It's not uncommon for individuals who are getting ready to be separated from employment to suddenly say, oh, well, I have a disability and you're discriminating against me, or you're firing me because of this, or I was subjected to hostile work environment while I was here. And we still have a duty to respond, even though this individual is on their way out. Okay. So we have to look at inherent plausibility. You also have to look at the demeanor. Watch body language. Are they nervous? Are they calm? Are they looking off to the side? Are they making good eye contact? Again, it's not necessarily an indicator that they're being dishonest, but it's certainly something that should be paid attention to by the investigator, and noted in the case file. The next thing that I look for is the motive to falsify. Would they have any reason to falsify information, make a false complaint? Is this a situation where they were best buds prior and then suddenly something happened to them, personally outside of work, and now they're at each other's throats? Or is this person not getting along with this person now because other personal reasons. So we look at, would they have a motive to be dishonest? Have they been a good employee or a normal mediocre employee? Would they have any reason to dislike this other person for something that may have occurred on a personal level? We certainly look for corroboration, are details matching up amongst various people that we're speaking with, and we look at the past record. Again, is this a good employee? Are the witnesses good employees? Have there been previous write-ups for certain things? We're looking at, have there been any issues with anybody that's involved in the process? Okay. So step number 7 is that then we make a decision. We have to be very careful not to jump to any conclusions, especially before we get all of the facts as best we can. If we do have credibility issues, we need to kind of work through those. Like I said, a skilled investigator is going to be able to evaluate all of that information and then make a formal recommendation. Now, typically when I do investigations, in my summary report, there's going to be a variety of options. Option 1 is our strongest recommendation. Here's what we would recommend in terms of action. And here's your liability, if any, associated with that. Option 2 is this, pros and cons of option 2, and here's your liability associated with that. Because at the end of the day, a skilled investigator is not going to make that employment decision for you. They're going to give you options for management to consider. And then it becomes leadership's responsibility to determine how aggressive or how conservative they want to be in their corrective action, as well as what liability are they willing to assume. Okay. No matter what, there will be liability in every employment decision that you make. Okay. Whether that is social media liability, legal liability. Again, people can make allegations of anything, even if it was a justful termination because they sexually harassed somebody or they physically assaulted somebody on property. They can turn around and file a wrongful termination charge or say, oh, well, you terminated me because of my race, and a non-protected individual, got into an argument and a fight with somebody else, and they weren't separated. So, complaints can have follow-up complaints, even with solid, robust investigations. So we want to make sure that we are always consulting with your HR consultant or your legal team, especially if you're doing an internal investigation yourself, to make sure that the investigation is comprehensive, that we're exploring all options for appropriate corrective action, and that the actions are warranted based on the investigative report. You got to look at all of the parties involved. We have to look at our policy and procedure, and we're also going to look at what precedence has been previously set. Okay. At the end of the day, the punishment needs to fit the crime. And we need to be consistent. So, if you let somebody go for it previously, then this person needs to be let go. If it was a written final one-time warning, then, if it's a similar situation, we want to follow that same precedence. Okay. In terms of determining the outcome, you have a couple of options here. We've got confirmation the alleged conduct did occur. We've got alleged conduct did not occur. We've got, we can't reasonably determine, or it has been completely refuted with facts and supporting documentation. Or the hardest one is that the investigation is inconclusive. We don't know whether it did or it did not occur. We can't refute it, but we can't prove that it did in fact happen. But so where some organizations do themselves, I think, sometimes a disservice is when there are inconclusive results, they kind of just leave it at that. They don't take it a step further and do, reminder training or coaching notes to the file and that sort of thing, which is something I would always strongly recommend there. Okay. So once we have determined the outcome, we need to close the investigation. So both the accused and the one who made the allegation need to be notified of the outcome. We determined this did happen. We can't determine, we're not sure, or it did not happen. And then we take the appropriate corrective action based on the situation and based on the investigative report. We need to be mindful of any sort of damages that might have been incurred by the victim. Again, hostile work environment, retaliation, and we want to make sure that we are remedying those damages appropriately. And then we need to determine if any sort of ongoing education would be beneficial to all staff or to certain individuals. Perhaps that is executive coaching. Perhaps that is referral to the EAP, the Employee Assistance Program. Perhaps that is a refresher course on communication and workplace bullying and harassment discrimination for all staff. So those recommendations on ongoing education typically are always going to be also included in my investigation report based on, again, the facts and the circumstances there. We may also need to go back and look at our policy and procedure and see if there's anything that needs to be modified, tweaked, redistribute workplace policies. Maybe this was a situation that's never occurred. We have a handbook that's a few years old and there was a gap in the policy. This is a perfect opportunity to, tweak that and re-roll out that policy. And then we determine whether the review of the investigation and the complaint resolution process is necessary. Typically that doesn't happen, but sometimes we need to go back and just make sure, again, did the complaint resolution process work? Where do we make tweaks to make it better for the next time? Step 9 is having a good, solid written summary report. Listen, in a perfect world, I want that whole case file wrapped in a pretty little bow. Okay. I should be able to open up that case file and look at every single statement and know exactly what happened from start to finish. Who said what is the evidence? Here's why we came to the decision that we came to. Facts, credibility findings, sources referred, all of it. Because again, if you get a charge of discrimination 300 days later, after this investigation is closed, that case file is going to be crucial in defending that charge of discrimination or crucial in giving it over to your attorney if there's civil litigation. Okay. So who made the final decisions, who was involved, issues that could not be resolved, and reasons for the lack of resolution. Typically, we see that when there's inconclusive evidence, and then employer actions to be taken to be solved as well. Okay. So with our corrective measures, on any of these state and federal regs, what the law requires is that we stop bad behavior from occurring and we prevent it from occurring again. Okay. So we look at disciplinary measures. It needs to be consistent. The punishment needs to fit the crime. It has to be properly documented, even verbal warnings, even if it's a written apology letter. Well, I want to see the documentation from the HR and the manager requesting the apology letter from the employee and the employee acknowledging it. I want as much solid documentation as possible. Okay. And so here's just a nice little checklist for you all on corrective measures: the date it occurred, the date of the action, the reasons. We're just doing facts only, policy, procedure, if there are any prior disciplinary issues with specificity that also relate to this issue. We're looking at the consequences based on the findings, outlining future expectations, allowing the employee to respond. Sometimes the employees are going to disagree with how you address it. That's within their right. They can write a rebuttal if they'd like. Have the employee sign all of the corrective actions. And then we make sure that we are following up that to ensure that the behavior is stopped, we don't have any issues, and everything goes into the case file there. Okay. So if we get an EEOC charge, again, you've got 300 days in the Commonwealth of Virginia to receive one of those. I mentioned EEOC, they're handling all of Title VII, ADA, age discrimination, equal pay. You used to get hard paper copies of that. Everything goes through the portal that they launched in 2017. So you'll get a notification via email there. And then you'll have to log in, look at what the charge is. Sometimes you don't have to respond. They're waiting on additional information. Sometimes you will, you'll only have 10 days to respond or 7 days. And you can certainly get an extension. But, EEOC secures, it's an older statistic, so I apologize about that. But in 2019 alone, over $484 million in victims based on discrimination in the workplace. So additional private sector, 355 million in monetary relief. So, if we receive an EEOC charge and we lose that charge, there is a lot of money tied in with that goes both to the victim as well as penalties imposed upon the employer for not providing a safe workplace. So the charge obviously is a complaint filed with the EEOC. As I mentioned earlier, it could be a rejected job applicant, it could be a current employee, it could be a terminated employee, or it could be somebody acting on behalf of an employee. The NAACP, a community advocate, that sort of thing can also file charges. When they make the complaint, it's under oath. They have to clearly identify the employer or the union if we have any union individuals there. And then they're going to describe the action that they felt like was discriminatory and what protected class they belong to it. So anybody can file the charge, again, up to 300 days from the date of the last instance. Here in Virginia, again, they changed the Virginia Human Rights Act with a modification to the Virginia Values Act that allows individuals to circumvent Virginia DOL, federal DOL, and go straight to civil litigation. So EEOC is going to be required to notify the employer of the charge, and the employer will actually get a copy of the charge. So they'll be able to see the whole paragraph and what the allegation is. And so when we get that, we need to look at, again, did we have knowledge of it? If we didn't, then we kind of scramble to figure out what happened. But perhaps it is a charge that was filed after an internal complaint was made. We fully investigated and we've taken closure to it. Those things do occur. That's why I want the solid case file around it. So we have to look at the allegation and assess the risk. Is this a blatantly false allegation? Is this something that doesn't even make sense? Did they check every single box on protected class plus retaliation and it is a frivolous charge? Other things that we're going to look at is, have we as an organization had multiple EEOC charges? Is it a topic that's flashy or newsworthy? Is it a manager that we've constantly received complaints about? All of these things matter when the EEOC looks at the entire record. Okay. So some administrative matters, typically with an EEOC charge, you're going to get a short period of time to respond. You're also going to have the option to mediate the charge out. Now, mediation has pros and cons. Okay. If it is a completely inflammatory charge and we know it's inflammatory, sure, you should respond. You should refute it, whether that be with your attorney, your employment liability insurance carrier, or your consultant. But typically, we always are going to tell you, no matter what, always negotiate a due date. Okay. They're going to say, oh, today is Tuesday, June 6th. You have until June 13th to respond. Pick an agent of record, have that agent of record contact the EEOC and ask for an extension. It's summertime. Our HR person is out of the office. We're working with our attorney. They need more time. ask for no less than a 4-week extension. Why? Because if we don't have anything in the file about this issue, we need the time to investigate so that the attorney, the insurance carrier, can appropriately provide a defense. Okay. So you can also settle a charge anytime during the investigation. Perhaps we get a charge and we know it's true. You're going to want to settle. Okay. It saves us time, money, effort associated with that. It can be an informal process. It's not necessarily an admission of liability or guilt, but it just kind of makes things quickly wrap up. Again, there are pros and cons to this approach. But once a settlement agreement is signed, it is enforceable. There should be confidentiality included in that agreement. It can also avoid the right to sue during the EEOC process, and that avoids lengthy, unnecessary litigation. Now, with settlement, typically comes a dollar figure associated with it. So whether that be $5,000, $50,000, you got to know what your bottom line is if you're going to settle. Okay. You can also move into conciliation, which is an attempt to resolve findings through an informal conference. So conciliation is a voluntary process. It's similar to mediation. It's a negotiation back and forth. Here's what we're willing to do for you. We don't think this happened, but we're willing to offer you this. They're going to come back and counteroffer back and forth, right? Sometimes this is a little bit more contentious, or it can be, because we are just trying to come to some sort of settlement. Again, not necessarily admission of guilt, but it can create some animosity. So if the alleged victim doesn't feel like they're getting what they want out of this conciliation process, then they can say, oh, I'm done. I'm enacting my right to sue. Okay. So similar to the internal investigation, the key is always preparation. You're going to investigate with an EEOC charge the same way that you would with an internal investigation. Okay. Pulling the history, having a solid process, looking at documents, determining relationships, potential bias, all of these things. Okay. So if we're going to defend the charge, then basically what we do is we look at what the allegation is, and then we go line by line and we kind of destroy it, for lack of a better phrase. Typically, I'm going to have a central theme. I'm going to clarify. I'm going to simplify. I'm going to back things up with signed, sworn affidavits. I'm going to provide evidence to refute their allegation. That may be statistics. That may be, providing clarification on consistency in policy and procedure. But remember, everything that we provide in that response to the EEOC is FOIable, which is the Freedom of Information Act, meaning that, again, it could be released to news outlets, that sort of thing. Okay. If you have an EEOC charge that's been filed against your organization, you need to keep a copy of that allegation, that charge, that response, and what actions were taken until the final disposition of the charge. And then you need to keep it for no less than 7 years after. Okay. So with the EEOC, they're similar to what we would do in that internal investigation. They're going to come up with, 3 options. The charge is dismissed, the charge cannot be reasonably determined, or the charge is confirmed, meaning you're at fault. Okay. So we want to make sure that if we do get a situation where the charge is not dismissed when it was received, that we are providing as much documentation as we can. Now, sometimes the EEOC will get a charge and they look at it and they're like, this is not worthy of allegation of discrimination, or this doesn't fall within the definition of harassment discrimination. They're not in a protected class, what have you, and they'll just flat out dismiss it. Okay. But if they don't, then we have to work with the investigator to make sure the most efficient cost-effective and least burdensome way to respond to the EEOC. Okay. Now, if you're not in a deferral state, individuals have up to 180 days to file a charge, but typically, once we get an EEOC charge, it can sit out there for months. Truth be told, I had one back in 2014, two actually. 2014 out of the Richmond Central office, the regional office there. And I don't know whether they got lost or what, but those charges are still sitting out there. Now, of course, statute of limitations, but typically it's going to take about 182 days from start to finish for the EEOC to look at it, investigate, do their interviews, look at what you're providing them, and then to make a determination there. I've seen some that take much less, 60 days, 90 days. But on average, it's about anywhere from 6 months. So you want to keep all your relevant documentations. You want to be cooperative with the EEOC investigator. And we certainly don't want to play games with them. As I mentioned earlier, there are compensatory punitive damages. There are limits on those. But if you have an age or sex discrimination charge, you can also get liquidated damages, which is going to double the penalty. So let's just say EEOC found your organization guilty and they fined you $100,000. With liquidated damages, that 100,000 automatically becomes 200,000. Okay. So for our managers, we want to make sure that they are setting good expectations with their employees, that they are walking the walk, talking the talk, that they are following our company policy and procedure appropriately and consistently, that they are collaborating with human resources or whoever is in charge of handling the HR side of things, to conduct prompt, fair, and complete investigations, and that we are taking appropriate corrective action in accordance with what the law requires, but also with what our company requires. So